Welcome, I'm Jon Caldara, president of the Independence Institute and your devil's advocate. A little later in the program, a talk about civil liberties and the disabled. It's particularly important to me, and I'll tell you why when we get there with Jeremy Meyer from the Denver Post, so you want to stay tuned for that. But first, Rob Natelson from the Independence Institute, our constitutional studies expert, and also master of putting in these amicus briefs to the Supreme Court. Thank you for being here.
It's good to be back, John.
Yeah. All right. This is pretty recent stuff, but this rather complex, but in some ways not that complex issue of vacancy appointments by the president. And it finally made it to the Supreme Court, and by all indications of how the lawyers were treated in oral arguments, there could be some real big changes on how the president gets to appoint people when, quote, the Senate's not in session. What's the issue? What's that?
John, this is a classic case of tug of war between the branches of government, in this case between the Senate and the President. The Constitution provides that usually the President, when he makes appointments, has to have those appointments approved by the Senate.
These are appointments for judges or cabinet members and all sorts of other
Right,
areas.
Including the National Labor Relations Board, which happens to be at issue in one of these cases before the Supreme Court. So that's the general rule, that these appointments have to be approved by the Senate. And the idea is to provide some check on the president and also make sure that the president appoints decent people.
Right, it's right. Advise and consent. So I want this guy in the Supreme Court. The Senate has to say, we give a thumbs up or a thumbs down.
That's right.
It's a check and balance.
That's right. Now, there is an exception to that because sometimes, especially in the early times of the Republic, senators went home, they weren't available. They went into what the Constitution calls the recess. So what happens when a vacancy happens in an office during the recess?
Recess. Because all right, so it's 1800. People go back to their home states.
That's right.
It's going to take weeks to get back, and that is a real recess. This is from one session of Congress to the next session. There's a time period in between. If somebody dies in office or quits or something, the president has the power to put somebody in.
Temporarily, that's right. The Constitution says he can appoint somebody, and that appointment lasts until the end of the following senatorial session. And that, as a practical matter, could be as long as 2 years. So presidents see this as a power that they can use to put people in offices, at least on a fairly long basis, without senatorial consent. And every president, it seems, not just Barack Obama, has been pushing this issue. President Obama perhaps has pushed it a little more than some of the others.
This is not a Republican or Democrat issue.
No, and in fact,
presidents want their appointees in office, and so they're going to say, "Hey, I'm just going to put them in."
That's right.
All right.
So you've got this argument going back almost 200 years. The presidents have argued, number one, that they can make a recess appointment in a recess that's shorter than the normal recess between Senate sessions.
What, you mean when they go home for Thanksgiving?
For Thanksgiving, 10 days.
It's a recess.
A month. It's a recess.
It's a recess. Here's my appointment.
Here's my appointment, and it can last for up to 2 years. The other thing that the president has been arguing is that if a vacancy actually happens while the Senate's in session, but then it goes home, the Senate goes home, and it hasn't been filled yet, maybe because the president hasn't appointed anybody. The president then argues that this vacancy has happened during the recess because it has continued into the recess.
Isn't that what we call a fib? So in other words, the Senate's in session, there's an appointment, there's a vacancy in a court someplace, and the president just waits until there's a recess and then appoints somebody and says, hey, it's a recess appointment, you can't do anything about it.
You would think it might be a fib, but I'll tell you, John, there have been many respected people who have argued that the Constitution's wording, which is vacancy may happen, that happen can include a continuing kind of recess. Attorneys general who admittedly work for the president have taken that position, but also commentators have taken that position. But the United States Court of Appeals for the District of Columbia Circuit said, no, that's wrong.
bring your part into this story, because this is where it gets fun. So here's a case of the National Labor Relations Board. This is the board that oversees unions, basically, and they're involved in a lawsuit. And if I got this right, the person they're suing, the company they're suing, saying, "Wait a second, you guys aren't the Labor Relations Board because you're recess appointments, and that's unconstitutional." Do I have that part right?
That's exactly right.
That's pretty cool.
The company took the position, Noel Canning took the position that 3 out of the 5 members of the Labor Relations Board were illegal, and therefore the National Labor Relations Board wasn't able to file a valid complaint.
Because they don't even have a quorum.
Yeah.
Because all right, so this went all the way to the Supreme Court and made big waves. You put in what's called an amicus brief. What did you do? What did you add to this?
Yeah. It's actually the Independence Institute that filed this brief, and it was based on my research. And it was research that I had already done. But basically what I did is what nobody had ever done before. I looked at those terms, the recess, and vacancies may happen, and I said, I'll bet you that those same terms were used in legislative practice back at the time of the Constitution, and that's probably where the framers got them. And so I started digging in 18th century legislative records of Parliament, records of the House of Burgesses of Virginia, records of other colonial assemblies, records of the early independent states, and also records of the Continental Congress. And what I found was, that's right, both of those clauses were very widely used, and they had real clear meanings.
What was that real clear meaning from before our founding, when Senate was in recess and vacancies may happen? What did that mean back then, and therefore, hopefully today?
The recess, the way that phrase was used, the recess, not just recess, but the recess, always meant between sessions. It didn't mean going home for Christmas or Thanksgiving. It didn't mean a coffee break. It actually meant the formal break between legislative sessions. And I don't know how many usages I looked at, but I couldn't find any to the contrary. The other one, vacancy happen. Does a vacancy happen because it continues into the recess? Answer, no. A vacancy happens when it's created. What's particularly interesting is there were some states that didn't want to do that. They wanted the governor to be able to appoint when a vacancy had occurred but they had different language. They didn't use the language in the Constitution. They used different language.
So on both of these points, when the Senate goes, all right, we're going to have a coffee break, we're in recess, gavel it down, that's not a recess.
That's not a recess.
And when they say a vacancy might happen, a governor can't or a president can't hold that vacancy until there's that recess and claim, well, it happened during a recess. At least that's what your research indicates.
That's right.
And that's what you put into your amicus brief that went to the Supreme Court.
That's exactly right.
All right. Give me the feedback that came back from the court. We're not going to hear what their final ruling is on this for probably a few months, but it seemed pretty clear there was some discontent about this issue.
Yeah, I think there was. The Senate goes into something that's called pro forma session. The Senate says we're still in session, but the senators aren't around. They have some guy, one senator comes in, he gavels them to order, and they keep it in. They keep themselves in session that way. And so
for this specific purpose, right? So that the president can't go, you're in recess over the holiday weekend, and I'm going to do this.
This would be at least one reason, right. Yes. So the Senate doesn't. There's no end run around the Senate's power to advise and consent. So President Obama took the position that even though they may say that they're in pro forma session, that this is really a recess. And so he went ahead and made his appointments. Well, the justices wanted to know how the Senate could be in recess when the Senate itself declared itself in session. Now, this is a very important point, and it's one that I didn't address in the amicus brief, but it's still very important, and that is legislative bodies are in control of their own rules. Generally, legislative bodies determine when they're in session and when they are in recess. And so there's probably an uncomfortable feeling among some of the justices that the president here is trying to make the rules for the Senate which of course is not the
Which you
president's
can't,
prerogative.
because we have these separations of powers.
That's right.
All right, and again, this is not R versus D. It's
No,
not
it's
like
not.
Obama's the first president to ever try this power grab, but it's becoming more and more popular. What happens if the court rules the way you would like them to rule, what seems to be in accordance to legal precedent since the founding, and that recess means we are now out of this Congress is over until we get reelected and the next one happens, that recess. What happens to this particular case? What happens to all these people that have been put into those offices?
I don't think that we're going to see retroactive invalidation of agency decisions going back many years, but certainly the Noel Canning Corporation is going to be able to defeat the claim against it, because it will have carried its point that the majority of the board, the National Labor Relations Board that's prosecuting it, is not validly appointed. And you're going to see a lot of other cases. You're going to see other folks that are being prosecuted by federal agencies that are dominated by these recess appointments move to set aside the prosecution. And you are also going to see a tussle between the president, between the White House and the Senate, as they try to work out a way of dealing with each other under the new rules, which I would argue are the old rules.
When you said, so I went back and I looked at these things from Parliament and from the House of Burgesses in Virginia from before the founding. What do you just have this crap in your library? I mean, I wouldn't even know how to start this. So as a constitutional scholar, and I want to remind folks, the book, The Original Constitution, you talk about the original meaning of these phrases, the original work. How do you get back to that? I mean, I can understand anything in the modern era has been typed and put into a book. Where do you find this?
Yeah, a lot of it is in fact on the internet. I mean, you can find proceedings, for example, of New York State in 1782 on the internet. It is sometimes hard to find all the volumes. And this may surprise some people, but the Denver Public Library actually has an excellent collection of founding-era legislative journals and proceedings.
Really?
So that's another place to look.
Right there with all the videotapes and DVDs. There's actually some stuff.
Right, and of course, the electronic stuff is wonderful because you can do a word search under the recess or vacancies happen, and see. Pick up 50 usages of the term in a particular book. So a lot of it is creative use of the internet, and of course, over the years, as a specialist in the founding, I've collected a lot of this material on my own computer.
When will we find out? When will the final ruling happen?
Certainly by next June.
Next June.
Yeah.
All right. Rob Natelson, congratulations. Another great victory. Again, check out The Original Constitution, available at better bookstores everywhere or Amazon. Thank you. Hey, stay tuned. You don't want to miss this. I want to talk a little bit about civil rights and the disabled.